You may be wondering, what is a deposition? What do I say? Who will be there? How do I prepare? You have a workers' compensation claim, and now the other side wants to take your deposition. By the time this video is over, I am confident you will have the answers to your questions. As always, if you still have any questions or concerns, please do not hesitate to contact your lawyer or case manager.
At Morgan & Morgan, we are here to make you feel as prepared and comfortable as possible. So first, let me tell you what a deposition is. Usually there are 4 people at a deposition.
The court reporter, you, your attorney, and the attorney that will be deposing you. The court reporter will be there to type everything that is said, every single word.
A deposition is one of the only opportunities the defense gets to ask you questions directly. Don't worry, we'll prepare you beforehand. You won't be there alone, but it's an important moment because the impression that you make during the deposition is going to have a big impact on whether they want to go to trial with you or they want to settle. You will first be put under oath by the court reporter, and then the defense attorney will begin asking you questions. You're required to answer them. The key is answering straight, short, and honestly. I want to make something perfectly clear. A deposition is not your day in court. There is no judge and there is no jury. Most folks want to tell their story, and a deposition can feel kind of like court. That's the wrong state of mind to be in when you come to your deposition. If the case doesn't resolve fairly, you will get your day in court. There will be a judge and there will be an opportunity to tell your story. However, this is not the time. This is an opportunity for the other side to try and trip you up.
You need to be mindful of this. They are not here to help you. Don't let them sweet talk you into letting your guard down and forgetting these things we're talking about. At the same time, you don't want to treat them like the enemy. You want to be pleasant to them, not sappy nice. That wouldn't be sincere. When you get into the deposition, you can say, yes, sir, or yes, ma'am. If you don't understand a question, say, I'm sorry, do you mind repeating? Instead of, I don't know what you're asking me. It's okay. You can ask them to repeat a question if you don't understand. It's how you do it that matters.
Remember, you don't volunteer any information. For example, they may ask, when you fell, how did it feel? What did it sound like? You answer, it was loud and it jolted and I felt pain right away. And you may want to say, and then I called 911. Don't. If they say, how did it feel? How did it sound? Stop with answering how it felt and sounded. They will probably say, what happened next? And you'll answer, I called 911. But if they don't, it doesn't mean that it's left out of your story. It just means that they don't know that part of your story. And the less they know, the less prepared they will be at trial, and less likely they're going to be able to hurt your case. If you are answering any question in more than 2 sentences, you are talking too much. Make them keep asking, what happened next? 2 sentences, that's it. So here's the rule. Answer the question honestly and in the fewest words possible. And do not volunteer information. It's that simple. Watch the tell me everything, list everything, and is that all questions. These are questions where the defense will try to get you to limit your answers so that if you later try to claim anything in addition, they can say, you remember when I took your deposition and I asked you to tell me every way that your back hurts? And I asked specifically, is that all? And you didn't tell me any others? And you were under oath. Now you've become a liar. So how do you handle that situation? These questions should never, ever be answered with a yes or a no. They should always be answered with, that's all I can think of right now, or that's all I can recall. Leave yourself an opening. Otherwise, you may be forever limited to only those answers that you provide at your deposition. Often, we forget things. It's part of being human. Often, more details come to us after the deposition. They just do. So, it's extremely important to leave yourself an out. Leave yourself that ability. Remember that it is human nature, and this is big.
It's human nature to try and convince others of the righteousness of our case. Therefore, it is only natural that you will try to convince the defense lawyer of your case. Do not do this. The defense lawyer is being paid hundreds of dollars an hour not to believe a word that comes out of your mouth. As a matter of fact, they're trying to make you out to be a liar. The defense is going to be asking you a lot of questions during your deposition. It's probably going to take a couple of hours. The other lawyer will likely begin by asking you general questions about your background, your education, family life, work history, and the facts leading up to and surrounding the work injury. Be aware that a significant portion of the deposition will likely focus on your past medical history and your current symptoms.
Of course, every deposition is different, but this is typically how a workers' compensation deposition goes. Listen to the question carefully, and if you fully understand it, go ahead and answer truthfully and in as few words as you can. While they're asking you these questions, you might be thinking, what does this have to do with my case? What does this have to do with the work incident that I was injured in? Well, this is what's called a discovery deposition under the law. What that means is that the defense is allowed to ask you a broad range of questions. The only questions they're not allowed to ask are questions that we call privileged. For example, they're not allowed to ask about conversations you had with your lawyer. If they ask you one of these questions, your lawyer will instruct you not to respond. But 99% of the questions they ask, if not 100%, will not be privileged questions, and they will be questions that you will need to answer truthfully. Remember, not to get defensive or upset and not to ask questions like, why are you asking me that, or why is that relevant? Unless your lawyer instructs you not to answer, it is a question they are allowed to ask. Remember that a deposition is not an endurance test. If you need to take a break to go to the bathroom, to gather your thoughts, to speak to your lawyer, that's absolutely okay to do. Just remember that before asking for a break, you want to be sure that you've answered whatever the last question that was asked.
On the day of your deposition, make sure that you don't bring anything with you unless your lawyer instructed you to do so. No list, no diaries, no journals, no cell phone with pictures. Leave that in the car. If you don't remember the answer to the question, don't look it up during the deposition. The defense lawyer is going to be asking you a lot of questions about a long period of time, spanning back years and years in your life. If they ask you a question that you don't know or you don't remember, it's okay to say, I don't know or I don't remember, but you want to be honest and credible in those answers. So if you can make a reasonable guess, you should do that and let them know you are not sure. For example, if they ask you the name of your high school or the name of your college and you say, I don't know, that doesn't sound very credible. Maybe you've forgotten the full name. Maybe they've changed the name since you graduated. But a reasonable guess to that question sounds more credible and more honest than simply, I don't know. Now, if they ask you a question that you simply cannot remember, or you just absolutely do not know, like the speed of the other vehicle in a car wreck, when you answer, I don't know, or I don't remember, they're not allowed to continue to pry. They will have to move on.
This is very important. Never deny the truth. If you have previous injuries, admit them. If there are issues that are true, acknowledge them. Remember, don't volunteer any information, but acknowledge if asked. The defense spends an incredible amount of money investigating you, your social media, your medical history, your employment, everything. It would be a horrible and potentially fatal mistake for you to fail to disclose any information thinking, oh well, they will never find out. They will. And it will ruin your case because you have just committed perjury. We can help you with almost any issue other than perjury. Remember that a majority of the questions being asked during deposition, the defense already knows the answers. Again, it is a test to see if you are credible, believable, and tell the truth. The defense will most likely have already pulled all past insurance claims you were involved in and will likely have already subpoenaed your medical records. You're going to do great, and this will be behind you soon. I suggest you watch this video a few times, and at least the night before your deposition. We at Morgan & Morgan are here to support you throughout this process, and please let us know how we can help you be better prepared and feel more comfortable for your deposition.